Good evening to everybody. I've been a student of history, and ever since 1971, I've been a great admirer and a fan of Professor Romila Thapar, and I must say it's an honor and a privilege for me to listen to her. And she has been able to converge all these ideas of renunciation, dissent, and satyagraha into one composite whole. I've also been an admirer of Mr. Tarkunde, having known him when I was studying law. Once in a while, I would bunk the law faculty, go to the Supreme Court to listen to eminent lawyers arguing cases, and Mr. Tarkunde was one of them. So really, it's a great privilege and honor for me to be here when two of my I've been a fan of both Professor Thapar and Mr. Tarkunde, and to be here in their honor is it's a great privilege and honor for me. When I started practicing as a lawyer, that's when I came a little more in contact with Mr. Tarkunde, because that was the time when I would go to the Supreme Court almost every day to listen to legal luminaries arguing their cases, and Mr. Tarkunde was one of them. And one of the things that I learned from Mr. Tarkunde, and I'm very grateful to him for that, was that we have the rule of law, but he taught me something called the principled rule of law. Now, what do I mean by that? It's all right, you can have dissent, you can have disagreement, but can you just have dissent and disagreement because you want to disagree or because you want to dissent? Or is there some principle behind the dissent? And I think that is what is very important, and I think that is what is Professor Thapar's theory also, which I could understand today. Mr. Tarkunde's definition of a rule of law was one of principled rule of law. So we had instances right in the beginning of my career as a lawyer when we had the supersession of 3 judges of the Supreme Court. Many people protested, many lawyers protested, but Mr. Tarkunde stood out as a person who said that in principle, I do not think that what has happened is correct, and he declined to go to attend the court of the Chief Justice as long as the Chief Justice was there. So even though the supersession may have been perfectly valid in terms of law, but the rule of law was still there, but the principled rule of law was missing. And I think that is what was highlighted by Mr. Tarkunde's, if I may use the word, boycott of the court of the Chief Justice at that time. Mr. Tarkunde's writings in the Radical Humanist on a very regular basis were also a great inspiration for me, and they also indicated the kind of person that he is, a person who had civil rights, human rights. Constantly he would be thinking about them and how to improve society, how to deal with situations on a principled basis. Now you can have all these ideas and thoughts, but like Professor Thapar said, that unless you have that moral authority, it just becomes an idea, it just becomes a thought, and nobody would accept it. But that was not the case with Mr. Tarkunde. I think he had tremendous moral authority. I could see that as a youngster, and I could feel that amongst the senior members of the bar at that point of time and the judges of the Supreme Court. And it is that moral authority, I think, which made him the great man that he was. Now, you could have, as a part of the rule of law, you can have cases filed against you for whatever reason. And during the emergency and even thereafter, cases were filed against people for maybe the smallest of all things. It's one thing to say that, well, if a case is filed against you, if you're not guilty, you will ultimately be found innocent, but that may take a couple of years. So how does it matter if a case is filed against you? But that's not the principled rule of law. The rule of law does say that, well, if there is an allegation, a case should be filed. But it is, I think, for the state, it is for the authorities to decide whether a case like this should at all be filed or not. If you know that a person is innocent, if you know that a person is not guilty, should you at all file a case against that person, so that afterwards, after a couple of years, he might be proved to be innocent. I think that is what stood out in the case of Mr. Tarkunde, because I remember seeing him argue a couple of cases where he felt that perhaps there was nothing much in the case that could be argued. And he was frank enough to tell the court that, well, on this particular issue, I don't think I have a case that I can argue. So I think that is one of the greatness of his advocacy, of his skill, and of the kind of person that he was. I think in view of the writings of Mr. Tarkunde, his actions when he was there as a member of the bar, I think he's had a great influence on a lot of people. Certainly on me, he has had a lot of influence because of the moral authority that he had and because of the conviction that he had in many of the things that he did, virtually in almost everything that he did. Freedom of speech and expression were dear to him. Civil rights, human rights were dear to him. And I think over the years, well, I've known Mr. Tarkunde now from the 1970s. It's been about 40 or 45 years since I've been influenced by him. I think today is a time when we need to really think about what Professor Ramila Thapar has told us about satyagraha, about dissent, about renunciation. Put it into action. Think of Mr. Tarkunde as he was. Think of his ideas, think of his writings, and see how we can try and improve society. So thank you very much, Professor Thapar. I think it's been a wonderful experience listening to you and, of course, reading all your writings. Thank you very much.
Thank you.